very excited to be able to feature guests from the Minnesota Center for Environmental Advocacy today, and very excited to say that Mr. Chuck Dayton will be providing the introduction. And as many of you know, Mr. Chuck Dayton was very instrumental in the legislation in 1978 to further protect the groundwater area waters. So thank you and welcome.
Thank you. I'm very happy to introduce my friend Kathryn Hoffman, who is the CEO of the Minnesota Center for Environmental Advocacy. She comes to us from Michigan via a joint degree from the University of Minnesota Law School and the Humphrey Institute of Public Affairs. Kathryn's, after a short time in private practice, she joined MCEA as a lawyer, and then 5 years ago became the CEO. And during that short period of time, I'm so proud of what she's accomplished there. The staff has grown from about 14 to 32, I think, and including a dozen litigating lawyers. So this is widely regarded as the most effective environmental advocacy group of general application in the state. Unfortunately, the good people keep getting hired away for government jobs, but that's probably a good thing too. They're interested in, as you will hear, PolyMet and mining in this part of the country, also air quality and climate change, water quality, and environmental justice issues. So, Kathryn Hoffman.
Hello, thank you so much, Chuck. We're so excited to be here today, not just because it's like 20 degrees cooler than it is in the city, but also because it's always fantastic to be up in Ely. We brought a few folks with us today, and I do want to introduce them before I get started, some MCEA staffers. Aaron Clems is going to join me up here in a few minutes. He's our Chief Strategy Officer. Aaron's going to wave. Yep. JT Haynes is our Northeast Minnesota Program Director, and he is out of our Duluth office, which we opened about 2 years ago. And that office is expanding, so we have a second staffer there as well, Abby Rogerson. There's Abby in the back. She's branded with our t-shirt. Well done. And Carrie Slater Duffy as well, who many of you have probably met because she does our individual giving program. So if you're one of our fantastic supporters here today, you probably talked to Carrie. So many of you probably know, but I should just mention who is MCEA and what we do. We were established in 1974 as a nonprofit that works on environmental advocacy and public interest law. So a big part of what we do is we are the environmental law firm for the state. So we represent a lot of other groups and organizations, and we work on a wide range of environmental issues, and we provide the legal expertise to do that. We also have policy experts as well as lobbyists. So we can work within all three branches of government. We can work with the agencies to get better permits or rules written. We can work with the legislature to protect and improve our laws. And of course, when we need to, and this is probably what makes us most unique, we can go to court. And we're going to be talking about that a lot today because that's what's happened on sulfide mining, particularly with PolyMet. Chuck, of course, was our first attorney for MCEA, so we're always pleased to have him introduce us. And as Chuck mentioned, we've been expanding. So we are up to 12 litigators here in addition to our lobbying and policy staff. So pretty excited about that. A lot of you have probably heard us speak multiple times, either myself or Aaron or some combination of us, talking about particularly the PolyMet mine proposal. This is a proposed sulfide mine that's located upstream of Duluth, as well as the Fond du Lac Reservation. And it would be, if it went ahead, the first sulfide or nickel mine to be built in Minnesota. And so I'm not going to belabor the point of why we're concerned about sulfide mining or PolyMet, because I think you've all heard that before for the most part. Sulfide mining poses greater risks as an industry than iron mining. It poses the risks of acid mine drainage, which can be extremely toxic to downstream wildlife and communities. We don't really have good examples of clean sulfide mines, and the pollution does tend to be for centuries, if not permanent. And so we don't have good strategies for cleaning up these sites. And so given that this would be the first mine in Minnesota, as the legal organization, we want to make sure the standards are set very high. And that's why we focused on this as an issue. And so I'm going to do a few things. We're going to talk for like 30-35 minutes, because one thing I know about all of you is you bring great questions, and I want to leave plenty of time for that. So here's what we're going to do. I'm going to give you a quick recap of where we're at in the legal cases surrounding PolyMet. We have a couple observations on what's changed since we started working on this issue. It was my first case in 2010 when I joined MCEA as a staff attorney, and I wasn't the first lawyer at MCEA to work on this. It actually goes back to about 2004. And so what's changed in these 20 or so years that we've been working on this issue? Namely, there's some new leadership at the federal level, which is more responsive to tribal interests. So we're going to talk about that a little bit. And another shift we see is we see mining companies talking differently about their projects, trying to make them about clean energy and climate change now, which is a recent shift. So we're going to talk a little bit about that. And then finally, we're going to talk a little bit about what is the change we hope to see going forward. I've rejected nearly every major permit issued by the agencies to PolyMet. The permits have returned back to the agencies in most cases, so the agencies have an opportunity to reconsider them. In the past, the state agencies have been in lockstep with PolyMet, but agencies are not supposed to be advocates. They're not supposed to pick sides, particularly against the public interest in this way, in our opinion. And so we're going to dig into a little bit this moment of where we're at and the opportunity that agencies have to respond and what we'd like to see more of. That's my roadmap. I'm going to start with a quick recap of where we're at. So as I mentioned, PolyMet goes back a ways. It actually started environmental review. The first comment period was in 2005. And their first environmental impact statement, which was both a state and federal project, because both state and federal agencies oversee it, was put out in 2010. And it was rejected by the Environmental Protection Agency. We also had concerns about it. And so they were forced to go back to the drawing board, and they put out a second environmental impact statement in late 2013 to early 2014. And that environmental impact statement was finalized in 2016. So that's good 10 years, 12 years in environmental review. 2 years later, in 2018, on the eve of the elections in November of 2018, PolyMet received their relevant state permits. So namely a permit to mine, which is the primary permit issued by the Department of Natural Resources, as well as the water and air permits. So they need a permit under the Clean Water Act and under the Clean Air Act. Those are federal laws. You probably know the Clean Water Act or the Clean Air Act, but the way they're structured, much of the responsibility is delegated to the states. So those permits were actually issued by our own state agency, the Pollution Control Agency. So that was late 2018. MCEA, along with our partner organizations, have appealed all of those permits. And all of these major permits have been stayed or remanded to the agencies or reversed. And I'll say a little bit about where each one is at. So the permit to mine went to the Minnesota Supreme Court last year, and the Minnesota Supreme Court expressed two major concerns about PolyMet's permit to mine. One is that they should have had a contested case hearing. This is a trial in front of an independent administrative law judge, as opposed to having the DNR decide on their own whether the permit meets the law. And it's specifically a requirement around keeping the mine waste away from air and water so that it's less likely to pollute, and whether they met that requirement. So they're ordered to have a contested case hearing. They were also told your permit has to have an end date. There's no end date on the permit, which just sounds kind of administrative, right? Like, why didn't you fill in that blank where the date is? But it's more than that. They actually have to show that they have a strategy for cleaning up the site and leaving it restored and put back into the landscape by the time that date is on there. And because PolyMet doesn't really have a plan, right now their plan is to leave an active wastewater treatment plant forever and ever and ever. That doesn't meet that requirement. They aren't able to have an end date. And so the court was concerned about that as well. So we're back at the agency and we've just started this contested case hearing. DNR has said they're going to put this question of the end date. They're not going to decide that until the contested case hearing is over. So the contested case hearing is, probably another year yet, maybe more. We don't really know what the scope is. We don't have expert witnesses. I mean, there's a lot of just preliminary wrangling going on. So that's permit to mine. The water permit, the Minnesota Supreme Court has ordered the Pollution Control Agency to address groundwater pollution. This is one of the big issues at these mining sites is that the water comes out the bottom of the mine waste containment facilities and then goes into nearby lakes and rivers. Mining companies have said in the past, oh, that's not regulated under the Clean Water Act. We don't have to worry about that. Courts have said otherwise, so they have to look at that. Some other aspects of the water permit are on appeal to the Minnesota Supreme Court right now, and we're briefing that. There's also a wetlands permit, and this is one we're going to talk about in a little more detail. The U.S. Army Corps of Engineers issues the wetlands permit, and it authorizes destruction of the wetlands in order to build PolyMet's open pit mine. However, the Fond du Lac Reservation is downstream from this facility. So there's a question of whether this mine will affect the water that's on Fond du Lac's reservation and violate their water quality standards, because Fond du Lac has their own water quality standard. And that is in a process right now. So that's the overview of the legal cases. It's a lot. We've got stuff, I feel like, at every level of courts right now: federal court, state court, court of appeals, Minnesota Supreme Court, all of those places. And that's why we have 12 lawyers, because it's a lot to cover. They don't all work on PolyMet, but many of them do, at least at some point. So that's my overview of the legal cases. What we want to talk about next is what's changed over time. So to talk about the first issue of new federal leadership, I'm going to hand it off to Erin.
Thanks, everybody. Just to reiterate what Kathryn said, my name is Aaron Clems, and I'm the Chief Strategy Officer at MCEA. In that role, I oversee the legislative and communications work, as well as work with JT on the Northeastern Minnesota program. I've been working on this mining issue both at Friends of the Boundary Waters prior to coming to MCEA, but also at MCEA. And that's why this recent development about the Section 404 wetlands permit has been really so fascinating for me, because I've been following this issue for over a decade. And really it signals a sea change in how the federal government thinks of their responsibility to tribes and to the communities downstream of these proposals, particularly PolyMet. And I think it's very fair to say that we're finally recognizing tribal rights and tribal responsibilities to tribal governments and people who live downstream. And it's really the result of new federal leadership in the Biden administration. First of all, I want to take a step back and remind people what the Section 404 permit is. Of course, there's so much lingo for all of these proposals. This is a permit that is needed in order to destroy or dredge wetlands. As Kathryn was saying, many of our federal laws are implemented at the state level by state agencies. This is a different kind of permit. And in fact, the federal agency issues this permit, the Army Corps of Engineers. And I think it was issued at least 6 or 7 months after the state permits were issued, so a little bit later in the process. PolyMet would be the largest destruction of wetlands permitted in Minnesota history. And of course, as you know, we've destroyed hundreds of thousands, if not millions of acres of wetlands over the course of our state history. This is just in our permitted history, this is a big one. Over 900 acres of direct destruction. That would be wetlands that are dug up. And then probably, we think, somewhere between 2,000 to 3,000 acres, or maybe even more, of wetlands that are dried out as the result of digging a big hole in the ground. As you can see right behind you, here we have Chagall Lake, right? We fill that with water. That water comes from somewhere, right? And that means that those wetlands that are immediately adjacent, many of which are peatlands that sequester carbon and are important habitat, will be dried out and potentially destroyed. And the risk, and that is not just about the reduction in wetlands, but also what comes out of them. And these wetlands are big sources and stores for mercury. And one of the biggest concerns about draining and drying out wetlands is that they release mercury into the waterways that go downstream, become what they call methylated, and become able to go and cross the blood-brain barrier and harm people and other creatures. And so that's where the destruction of wetlands really becomes a big issue for water quality, not just the loss of wetlands, but what it does to the water that flows downstream from that site. And so tribal governments have been noting this for a very, very long time. The Fond du Lac Band of Lake Superior Chippewa has been absolutely a leader on this issue for many, many years. And I think I just want to make sure that everyone's clear on this. This is their case and not ours. We have a separate challenge to Section 404 permit that is kind of in stasis while this plays out with the Fond du Lac Band. And I wouldn't in no means want to suggest that I speak for them in any way. I don't. I'm just here to give you an update about what's happening and how we see it. And the Fond du Lac Band has been repeatedly raising these issues for a very, very long time. And I want to make sure folks understand that the Fond du Lac Band has been part of the environmental review process going back to 2005. They have repeatedly raised these concerns as part of environmental review and of permitting. And at all stages, their concerns and evidence and science they brought to the table has been largely disregarded. That big environmental impact statement, I'm sure if you were around in 2013, 2014, you remember the big controversy around that. Eventually, the agency stopped trying to answer the Fond du Lac Band's science and questions about the environmental review and just relegated them to an appendix and said major unresolved differences of opinion is the way they described it. That's how that's supposed to work. I mean, when you do environmental review, the goal is to resolve differences of opinion using science and the law. Right, and we never even reached that resolution in the case of the Fond du Lac Band and the environmental impact statement. And a lot of that was because they punted it to permitting. They said, "Okay, look, you're right, Fond du Lac, but we'll address these issues in permitting." And so now we get to this actual point where you have to make a decision: does this proposal meet federal law? And originally, when this permit was issued, the EPA chose not to determine whether or not this would affect Fond du Lac's water quality or violate their water quality standards. I want to repeat that because it's a weird sentence. The EPA chose not to determine whether or not this would have an impact. Right? They thought it would be more legally defensible to just not make a decision under the law. And there's a section of the Clean Water Act where they're required to do that. And eventually, the courts recognized that and forced the EPA to make that determination, what they call a may affect determination. And they did find that the water quality standards of the band, which are in some ways more stringent than Minnesota's standards on mercury and on a number of other issues called specific conductants. These are salty pollutants. Basically, how much electric current can pass through the water is kind of the way that they measure this. That's why it's called conductance. But the upshot of all of this is that EPA said, you know what, this probably could violate their water quality standard. And then they started a next step, which is determine whether it will violate Fond du Lac's water quality standards. You may have seen some news coverage of a hearing that was done at the Fond du Lac Band Reservation, where the Army Corps of Engineers came and heard evidence from the EPA, from the band, and from PolyMet. And the EPA's recommendation has been to not reissue this permit as there is no conditions that can be imposed on the permit that would actually allow them to meet Fond du Lac's water quality standards. If the Army Corps accepts this recommendation, and it would be very challenging, I think, for them not to do so, this could very well spell the end of this project's proposed, in part because in order to avoid wetlands impacts, they would have to do really radical changes to this proposed project. Right now, they plan to build 3 open pits covering about 1,000 acres, and you would not be able to do an open pit mine and comply with the EPA's thoughts about whether or not this would pollute water downstream. But I want to take a step back and just kind of remind people how we got here, right? That this is where federal agencies, once being told by the courts that they have an obligation under the law, rather than fight that, they said, you're right, we need to do that. They put the permit in suspension, they stayed the permit. They started this process of using science and the law to determine whether or not the downstream tribe, in this case, the Fond du Lac Band, whether their water quality standards would be violated. And now we are in a process to actually make that determination. And that's the way the process should work. And I wanted to lay that out a little bit, and I'll come back to this theme in a moment. I'm going to turn it back to Kathryn in just a moment. This is the way the process should work. We should be using science, rules, and the law to determine whether or not this proposal meets them. And we really applaud the recent focus of the Biden administration and the federal agencies to take this obligation very seriously. Not only to meet the law as it's described, but also to pay attention to the interests of tribal governments downstream. Whereas the previous administration really decided just how do we avoid living up to that responsibility. I think now we're actually trying to figure out how we live up to that responsibility. So the nuts and bolts, just one last thing before I turn it over to Kathryn. What's next? There was a comment period that recently closed on June 30th. It was oddly restarted after it ended to extend it. We understand that PolyMet asked for that extension. We're still trying to figure out why. Over 20,000 public comments were sent in support of the ban's position from a number of national and statewide groups. MCEA and other groups submitted scientific evidence in support of the ban's position. We, of course, not alone in that. A lot of groups across the nation supported the ban of this. And now it's in the hands of the Army Corps of Engineers, who will make a decision. And I'm sure I will not shock you when I say it's likely to be challenged in court, regardless of what that decision is. But I think that this is a good example of what we expect our agencies to do when courts tell them that they haven't done their job correctly. And I will be coming back to that in a little bit, because I think there's some pretty big contrasts between that and the state permits that have been remanded or returned to the agencies here in Minnesota. I'm going to turn it over to Kathryn next. She's going to talk a little bit about the change in rhetoric and also some of the ways that we're trying to respond to this recent talking point of the industry that their mine is necessary for climate change and for greenhouse.
You didn't get any applause.
I told them not to.
I'm just teasing. All right, so I want to talk about another change that we've seen, and this one's also pretty recent. It's a rhetorical change, I guess, in the way that mining companies talk about why people should support their proposals. And nobody, I think, is probably more familiar with the rhetoric on both sides of mining than the good folks of Ely, Minnesota. And so I don't think I need to tell you that for many years, the mantra has been jobs, jobs, jobs. And that's the thing that people have sought from these mining operations. And increasingly, we're seeing a shift. We're starting to see mining companies talk about their the need for their operations in order to fulfill metals demand to support the shift to renewable energy. So you hear talk about wind turbines, need for steel for wind turbines, lithium, nickel, cobalt, and copper, all needed for electric vehicles, for example, especially the nickel and the cobalt. I mean, I do want to note that, it's been in 20 years, we have put in probably 10 comments on the PolyMet proposal. And one thing we've said every single time is you should do on-site generation. You should put some solar panels here. You should put some wind turbines here. There are mines around the world that do this, and it helps improve the carbon impacts of their operation. And that's not something that PolyMet's ever really even responded to. We don't have legal tools to make that happen, but we always thought it'd be a good idea, so we've always put it in. We've not gotten any traction. So I do think there's some tension here between the notion that these mines are good for the renewable energy transition and mining operations that have historically opposed renewable energy. But besides that, there are other reasons to be skeptical of these claims, in our opinion. And so MCEA has actually dug pretty deep into this question. We have a series on our website called Mining the Climate Crisis, which is a series of web articles that looks at this issue. And so I encourage people to go and look at that. I'm not going to talk about all of it here today, but I think this is a really important conversation for people to have. But here's a few sort of top line things I want to say about this. The first thing is that we do have a ready supply of domestic metals that we are simply landfilling, over 1 billion tons every year. And so focusing on policies to reclaim and recycle metals is cheaper, It's faster because we already have those metals, and it's cleaner than any mining proposal. In many ways, this is a material demand that we deal with just like any other material demand. We reuse, we reduce, we recycle. Everybody remembers those. And then only if we absolutely need to do we get to a responsible mining operation. We have not even begun really to explore these first three. Our recycling rates are low here in Minnesota and in the United States. And we do have a lot of policy options in other countries as models to improve those recycling rates. So that's the first thing. The second is that mining proposals themselves have tremendous climate change impacts. Aaron mentioned the Wetlands Permit. A lot of those wetlands are peatlands. Peatlands are a tremendous carbon storage sink. And digging those up releases that carbon. That's not a good thing to do. They also use a lot of energy. And here in Northeast Minnesota, we see Minnesota Power actually justifying the need for fossil fuel plants based on projected future demand for mining operations. So they're actually saying we need to keep our coal plants open longer, and we need to build a new fossil fuel plant in Superior, Wisconsin, in order to support this demand. When in fact, there are other ways to fulfill that demand, like renewables, but it does make the mining industry, a pretty carbon intensive prospect. And so our position is that mining should be a last resort because it's destructive wherever it happens, even if it is done well, even in the best of circumstances, it's still destructive. And it's better for us to look at recycle and reuse first. We think that it is important to pay attention to the products we use. And that this is an important conversation to think about how demand and climate change intersect. And so we do appreciate that there's attention being paid to this, but we do want to be careful that it's not used to justify destructive mining practices, because I think we can have both, metals use for the renewable energy transition, as well as protecting our clean water. And indeed we have to, because as the climate changes, water is going to be one of our most precious resources, and we want to protect it. So this is a communications issue. It's not really a legal issue, but MCEA does also do a lot of work on communications, and that's the conversation you'll find at our website. So we wanted to talk about that today. The last piece of our talk, and then we'll open it up for questions, is what would we like to see going forward? And Aaron's kind of foreshadowed this a little bit, talking about how we want agencies to behave in the face of court decisions. So I'm going to hand it off to Aaron for the last piece.
Before I start, I just want to shout out Abby in the back. She's the one who's written all of these awesome resources for our website. They're really great. Again, I can't stress enough, like we're seeing national groups like Earthwork share these resources, because this is one of those conversations that's happening nationwide, right? We're not just having it here in northern Minnesota, we're having it across the world. I think, one of the challenges with this work, and I've now been doing this for about a decade, maybe a little bit longer, is how much it lays bare kind of what you think you want the world to look like and how it actually operates. Let me back up a little bit, right? I mean, obviously facts and rules and science are kind of MCEA's like thing. That's our brand, so to speak. That's what we want the world to operate. And we want decision making to be built on those pillars, on those bases. But we see how political decision making is. I mean, it would be impossible for a thinking, breathing human being to look at the environment we have right now, whether it's in Washington, D.C. or St. Paul, and conclude that all that matters is science, facts, and the law, right? Obviously, the political dimension has gotten really heavily involved. It's been fully on display in the PolyMet debate over the last decade or more. And so, I come into this question quite fundamentally because I grew up as a switch side debate person. I debated policy debate. I was trained that my job was to debate on both sides of an issue, that try to understand what the other side's arguments were. Not that that was some kind of source of weakness, but rather a source of strength, to really understand that there were multiple perspectives on every issue, and that your job was to try to understand what those were. right? And that the goal of the debate was to bring out the facts and to reach conclusion by putting those facts to the test, right? I mean, that's kind of the romantic version of what we want our agencies and our decision makers to do. And I think, are we a state, a nation of laws, or are we a state or nation where political will and who has control of the political apparatus at any given moment is all that matters? And I think we're all struggling with this right now. I mean, I think the Supreme Court decisions that came down during this decision there's a ton of themes that resonate with this. I mean, whether we're talking about the recent Dobbs decision in regards to reproductive justice and abortion access, or whether we're talking about the EPA's decision on whether the EPA has the authority to regulate greenhouse gases, right? There's a lot of talk, and I think well-founded talk, about whether or not we're seeing a fundamental shift away from some of the bedrock principles of how we thought about how the legal system works and the way our political system should work and the way our agencies should work toward a more kind of who's in charge gets to decide kind of realm. And I just got to say, from a personal perspective and also from an organizational perspective, that is not an outcome we want to see. I mean, I think our goal, and I mean, my goal personally, and I think our organizational goal as a whole has been to drive decisions based on science, facts, and the law. We don't engage in electioneering. We're not a political organization. We're a C3. We can't, by law, do that. And so from our perspective, it's essential that key decisions, such as whether or not these permits meet the law, whether PolyMet can be permitted under Minnesota's rules of law, we want them made on the basis of science, facts, and the law, not on political will. And obviously, political processes set the rules of the road. I mean, we have laws because we had politics, and the politics helped set what those laws were, right? Obviously, political outcomes determine who sits in the seats of power and makes decisions, right? So by saying that I want science, facts, and the law to determine these things, that is by no means saying that politics has nothing to do with it. Of course it does, right? But then there are different roles that each should play. And the part that's really kind of been, a theme that's been developing over the course of our legal work and then the subsequent response to some of these decisions by agencies is about whether agencies are advocates or whether they're decision makers, right? And in too many cases, I think we see our state agencies treating themselves as advocates for proposals, in this case, the PolyMet proposal. And courts really do pay attention to this. I mean, there's a lot of decisions and precedent to look at. And I won't go into cases, but just, a lot of our cases involve questions about what they call warning signs, whether an agency has been, whether a permit is the result of the will of the agency or the result of a reasoned process that the agency undertook to make a decision. And if they decide that, if the court decides that a permit is the will of the agency in the face of facts in the law, then they oftentimes will reject that permit. And Minnesota courts in their decisions rejecting permits issued to PolyMet made it really clear, especially on a number of cases, that they're just basically saying, look, agency, you didn't do your job, but we're not going to tell you how to do your job. We're going to tell you that you didn't do it. And we expect you now to go back and fix these problems. And we're going to tell you what the problems are you need to fix. But we're courts, your agencies, your experts. We're just here to tell you what the law means. And we're going to trust that your next steps will be to implement this. And that is where a lot of the real rubber hits the road when it comes to these court cases. You can win an appeal, but if it gets kicked back to the agency and they just repeat what they already did and put it right back out, you haven't really won anything, right? And so it's a real challenge for us. And it's a big and understated part of our work that after a decision is made, right, we're tracing and working through those processes that follow, right, to make sure that from our view, the court decision that kicked it back to the agency is being respected and that they're doing the work that's required. And a couple of examples of this, you may have seen stories about the air pollution permit for PolyMet. It is now on appeal for the third time. Twice it was rejected by the Court of Appeals and sent back to the agency. The second time it actually stuck, and all they did was reissue the permit with an extra 2 pages, basically, of explanation, and made no changes whatsoever to it. Despite the fact that the court basically said, I think quite gently, hey, there's a lot of evidence here that MCEA and others have presented that there's a proposal to expand this mine well beyond the scope of its permit. You should probably look into that. And their response has basically been to say, no, we're not going to investigate that. When PolyMet proposes a new air pollution permit, we'll look at that. Until then, we're not going to do anything to change this permit. That case, by the way, is tangled in some interesting, and I will not belabor the point, procedural motions right now, but we hope to have that case back on a substantive level in front of the Supreme Court very soon. The water permit, I mean, we've known for a long time that the water that comes out of the base of that, the toe of that tailings basin will not all be captured, and some of it will be polluted, and it will violate our water quality standards. However, they've said, you know what, groundwater is not regulated under the Clean Water Act. We don't know what you're talking about. It's basically the kind of response we've gotten. Finally, the US Supreme Court said, no, if there is a functional equivalent of pollution of water, in other words, you polluted groundwater and it came right to the surface, then you have to regulate that under the Clean Water Act. They could have long ago have recognized that responsibility and done something about it. Instead, they've chosen not to. And it's not just this permit, the Mintac permit, for example, which was one of the cases that we brought as an example to the Supreme Court when we represented the Fond du Lac Band as an amicus party to the US Supreme Court in that case, has still not issued a permit. Ironically, when the MPCA was asked about this, they said, oh yeah, we do this all the time. We did that with the Mintac permit, and yet they still haven't reissued the Mintac permit. So we're a little bit confused about that. I mean, I could blather on about this, and I'm not going to do it. But instead, I want to get back to kind of what the point is, which is what we expect from our agencies is that they will take these court decisions and understand their job, right? Which is to be the experts that implement the law and look for facts and science to back it up, and not to be advocates for the project. I think a lot of times it's been challenging for me personally to read some of these decisions because, more the briefs that are submitted by the parties. Just last night, the Minnesota Pollution Control Agency submitted a new brief in the water pollution permit case at the Minnesota Supreme Court. And that case is now mostly about whether or not they were in the wrong when they deleted emails that showed that they asked the EPA not to comment on the final permit for the water permit. You know, obviously politics got entangled there. And we know for a fact from an extensive amount of research, and also the fact that the union representing the EPA employees brought forward these emails, that there was a concerted effort to keep the public in the dark about significant concerns that the Environmental Protection Agency had, whether or not that permit would protect Minnesota. And what was really galling to me was reading once again the assertion by the agency that that was no big deal. That was not a problem. You know, and if it was a problem, it wasn't that big of a problem. And it certainly didn't mean we should do anything different. I mean, this to me is kind of the fundamental of what we expect our agencies to do. Our Environmental Protection Agency is the experts on what will happen and whether or not a permit can meet the law. And for our agencies in the state to basically try to find a way to go around that, circumvent it, keep it quiet, keep it under wraps, that's a big concern for just good governance. And that's part of the reason why you've seen so many groups, such as the Minnesota Coalition on Government Information, Public Records Media. These are groups that do government records requests and public data requests, have come in on our side on this case because they were very concerned about the precedent this might set that says, hey, if you don't like what another agency says, keep it quiet, delete the emails, and destroy the evidence. What's a better approach? The better approach is what the Army Corps is doing. I mean, what they've done is said, we know that there's a need for a change. We know that we have not met the law, and our job is to work with all parties to identify the right procedure, implement it with dispatch and transparency, and let the public participate in it. And spend less time fighting over process and more time gathering information and making a better decision. I don't think anyone can disagree with that. But it's also, you know, I think it's indicative of the moment we're in politically in our country, right? That we are struggling with this question of whether or not facts, science, whether we're a nation of law or whether we're a nation of political will. And I hope that it gets resolved in the favor of we are a nation of laws, because there's a real cost to this. The costs are financial, right? We have repeated cycles of court challenges. Every time an agency says, we're going to do the bare minimum to respond to this decision and not really implement it, it means that nothing changes and we go back and challenge it again. And as we've seen in the air permit, we keep winning. They have to meet the law. And I think that the courts have been actually a little bit overly polite at times to basically tell them, you know what, you've got some leeway here. Our job's not to tell you how to do your jobs, just that this permit as issued doesn't meet the law, please fix it. We hope our agencies will do a better job of implementing that. Otherwise, we end up having to challenge the next issuance of that permit. We've already spent millions of dollars in an outside law firm that primarily represents the mining industry, nationwide. They represent the state of Minnesota in these procedures. I think we're over $10 million now in taxpayer dollars being paid for that law firm. But I think ultimately confidence in our agencies, confidence in our government, confidence in our democracy, is at stake here. Because if we can't trust that agencies, regardless of which party is in power, will do their job, then we have a real problem and one that's very difficult to solve. So we hope that as part of our work that we're helping advance this conversation, that we're helping, in the future of these cases, it's obviously of paramount importance for the water and people that live downstream. We care very much about these cases, but we also care very much about the principles that underlie why we're involved in these cases. And I hope that this little rant has at least given you a little insight into how we think about this at MCEA and how we're approaching this work. And I'm going to turn it back over to Kathryn to conclude this and open the floor to questions, if you have any questions.
Not rants. So MCA, I just want to mention for everybody that we do work on more than mining. We often come and talk to you about mining up here, but we have other work. We have an entire team that works on climate and energy that's working to stop new fossil fuel plants and bring more renewable and solar online, as well as support the transition to electric vehicles. We have a water team that protects our water from agricultural pollution, which is by far the biggest source of water pollution in the state. We just had a case up at the Minnesota Supreme Court about that as well, and we are waiting the outcome to protect our public waters from agricultural pollution. And we work on environmental justice. We partner with communities that are historically overburdened by pollution to help partner with them to fight particularly industrial pollutants in their neighborhoods. So we do a lot with our 32 staff, and there's some materials out front. So if you have an opportunity to take some, and if you're moved to make a gift, we very much appreciate it, because most of our funding does come from individuals like you. So thank you. And now we'd love to take some questions. Any questions? All right, Lacey's in charge.
Yeah, well, I've got the microphone. I'm going to give you the microphone.
One of the bombs that the U.S. Supreme Court has dropped in the last couple of weeks is an environmental case in which they said that the EPA didn't have authority, as they thought they had, to regulate emissions from coal plants. And I'm wondering, first, what effect that has on the state regulation of coal plants, and also what's your sort of general overview on where we're going or should be going on climate change?
Yeah, good question. So that's West Virginia, the EPA. MCEA actually was a party to that litigation. We were not the attorneys involved. We had other attorneys who appear in the U.S. Supreme Court much more often than we do. So we were following that very closely. So effectively what had happened is the Obama administration had implemented the Clean Power Plan. And the goal of the Clean Power Plan was to shift overall energy generation away from coal and towards renewables. And the strategy that they were using looked at the energy mix and then permitted some trading in order to encourage that movement towards renewables. What the U.S. Supreme Court said was that the authority of the agency doesn't include that trading scheme. That they may be able to regulate carbon, but only at each individual plant. So they call it within the fence line at each place, and not like an overall scheme designed to encourage a shift in the energy mix. Practically speaking, the Clean Power Plan was never implemented. It was stalled in court before it even went anywhere. And in most places in the country, including Minnesota, that utilities have far exceeded the goals of the Clean Power Plan. So one issue there is it was arguably quite inappropriate, not even arguably, I'll just say it. It was very inappropriate for the court to take this case because courts need to have a case or controversy, and nobody was actually fighting about the Clean Power Plan anymore. So they should not have taken this case. I think I and many others were concerned that the decision would be worse, which is mostly indicative of the bar that we have right now, which is the Supreme Court, where we don't trust them to follow precedent. They did not disrupt the original finding that the EPA had the authority to regulate greenhouse gases under the Clean Air Act, which is a good thing. They also cited, I thought this was interesting, they cited approvingly a particular rule that regulates mercury and air toxins called the MATS rule, which did very dramatically reduce mercury emissions from coal plants. And so there is some potential going forward, and this is, I think, where the EPA is going to go, is for them to regulate at a site-by-site basis the greenhouse gas emissions from each plant. But with that support for the mercury rule that was cited in that decision, I think it allows them to regulate it pretty drastically and say you have to bring this down to the point where some coal plants may not be able to meet the standard. Hopefully that's where we go. The impact in Minnesota is zero. The immediate impact, most of our shift in utility mix is driven by state law. So we have the Next Generation Energy Act. So we have our own greenhouse gas emission goals and statute. And we have some other laws around preferences for renewables that our utilities and our Public Utilities Commission, which is the state board that regulates utilities, has generally used as tools to push our utilities towards renewables. And here in Minnesota, all of our coal plants are either closed or slated to be closed by 2030, except one, which is great news. And I will brag about that a little bit because MCEA's attorneys have been involved in every one of those cases up at the Public Utilities Commission to push for that outcome. So we did play a role there that we're very proud of. And so those state laws and our Public Utilities Commission are largely pushing that progress. I think the main impacts of the US Supreme Court decision are that it's yet another tool that's been taken away from the EPA. It's increasingly clear that we need congressional action. We all got bad news about that this week as well, with Joe Manchin, pulling the football away again, playing, Lucy to the rest of the Senate Democrats, Charlie Brown, and this negotiation process of trying to get some sort of climate bill passed. So I think that this next election is going to be a big one to decide that. Congressional action is pretty important for national movement. In the meantime, by far the best tools we have are state-by-state regulation, which is, at least in Minnesota and other places, is pushing our utilities along. They just need to move faster. Was that everything you asked? Okay.
Yes.
Cool. I think there are other hands. There's one up here.
I was just wondering
why they're always talking about the copper sulfide mines for sulfuric acid or battery acid, getting into groundwater. Is there any danger from like copper poisoning? Because they don't really ever bring that up, or is that I'm assuming that's detrimental to wildlife as well.
Right, yeah, so copper is, that's okay. So the question was about copper poisoning from sulfide mining. Copper is a toxin and it's a regulated pollutant. So we have water quality standards that set those. And it is an issue, and it's associated. I think the reason people focus on the acid is it does tend to be associated with the acid. And so what happens is when these sites go acidic, that acidic condition leaches out the heavy metals. And so the accompanying condition is much higher levels of copper and of arsenic and some other heavy metals that are toxic to aquatic life. And so some years I brought a graph. We don't have any slides this year, but we have a graph that's in the appendix of the PolyMet EIS. And what it shows is projected pollutants over a 200-year period. And there's a whole bunch of them, but there's one for sulfate, which is a big concern. And there's also one for copper. And what it shows is that the level of copper projected to be in the water that would flow out of the site is well above water quality standards and remains there for 200 years, at which point they flipped off the simulator and we don't know what happens after 200 years, but I think we can assume it's not a radical change. And so you do actually have, there is an issue of copper poisoning as well at these sites, and it's much more likely when you get the acidic conditions.
Thank you for this presentation. You're busy keeping your main eye on PolyMet and another eye on what's happening with the commercial south of Ely here. Are you also keeping an eye on the development in Aiken County? The mine that's being planned by Rio Tinto, which is a subsidiary, Kennecott, which is a subsidiary of Rio Tinto, and the new company Talon Minings or Talon Metals. And I imagine you're watching what's happening there. That's the headwaters of the Mississippi and arguably of the St. Croix, Kettle, and so on. That's another important area. And thereafter copper, nickel, the platinum group, and even iron with this mine. I imagine you're keeping an eye on what's happening with that. Are you concerned about the gimmick that they've come up with of partnering with Tesla? Or here Tesla will give you the nickel ore, or will sell you the nickel ore, which I think is kind of a gimmick. I don't know for sure. You see that spreading? Is that infectious?
Okay, yeah, great question. So the question is about the proposal. It's referred to as the Tamarack site, and Talon is the company. And if you're keeping track, we've now hit all three major watersheds in Minnesota with Twin Metals in the Rainy River, PolyMet in Lake Superior, and this Tamarack site in the Mississippi River watershed. And yes, we are paying close attention. So this is primarily a nickel mine. And what the company is proposing at this point is a shaft design. So what that means is they would go in, it's closer to an underground mine than an open pit in terms of the design, take out a fairly rich deposit of nickel over a fairly short life. This proposal is in the very early stages. And if you'll indulge me for just a minute, I want to say a little bit about the playbook of mining companies and the early stages, because we've seen it before and we will see it again. Mining companies have a strong interest in marketing their proposals in a particular way early on. And for PolyMet, we saw actually a similar ploy early on. They had, I don't know if it's a ploy, that's not fair, but they had a proposal early on that was actually like a mine mouth copper finishing plant. I don't know if people remember this. This goes back to like 2005. And what they had proposed was that you could actually buy copper wire that was made by PolyMet, like at the mouth of the PolyMet mine, and it would just stay domestic. You could buy Minnesota-made copper wire, which is a really interesting idea. And that was dropped shortly thereafter. I don't know, maybe 06, 07, something like that. This may have been a serious proposal. It may not have been. I really don't know how much work they put into it. But the playbook is fairly clear, which is that mining companies can make marketing promises early on and then drop them with minimal penalty. So in the case of Talon, what Talon is doing is very much related to this conversation I brought up earlier about mining companies talking about themselves as a solution to climate change. And what Talon is saying is we need nickel to put into the batteries of electric vehicles. And so that's what we're going to do. We're going to create a domestic supply chain for nickel. Now, one problem with this is we don't have a way of processing that domestically right now. And so it's not clear how we would even make it into the batteries in the United States. We don't have that. We don't have facilities that do that here. But another problem is that the contract they signed with Tesla expires in 2026. Well, I don't know if you remember that timeline I gave you on PolyMet. Talon's not going to have a mine by 2026, right? And so in 2026, either this contract will simply get dropped and nobody will mention it ever again, probably, or, maybe it will become a real thing and Tesla will actually